A sponsor raises Regulation D private placement equity for real estate development financing, lines up senior commercial debt, and then the operating agreement slows the loan because senior lender subordination conflicts with mandatory distributions and investor liens and foreclosure rights. The sponsor thought it had a bankable capital stack because the pro forma worked. This is Syndication Attorney Field Notes with Tilden Moschetti. I'm Tilden Moschetti, a syndication attorney. Today's field note is about why a profitable development deal can stall when the equity documents do not fit the senior loan. The plain English answer is this. The senior lender is not only reviewing the numbers. Bank counsel, meaning the lender's lawyer, is reading the operating agreement and the private placement memorandum. They want to know who gets paid first, who controls cash, who has rights in the property, and whether the investor money is true equity or competing debt. A clean pro forma proves the deal can make money. It does not prove the deal is bankable. Commercial lenders do not finance spreadsheets. They finance legal structures. The common sponsor mistake is thinking lender approval starts and ends with the pro forma. The numbers matter. The cost budget matters. The projected rents matter. But the lender also wants to know the legal order of the money. Senior commercial debt sits at the top. It is secured by the property. It is paid before equity. Investor equity sits below it. That is the basic deal. Subordination means the investors stand behind the senior lender in the payment line. So if the operating agreement promises investors payment rights that compete with the bank, the lender may ask for changes before closing. This is where the sponsor gets surprised. The sponsor may say, the investors agreed to these terms. That is true. But the senior lender did not agree to them. And if those terms affect cash flow, collateral, or payment priority, the lender is going to read them. The distinction that matters is financial feasibility versus legal feasibility. Financial feasibility asks, can the project make money? That is the spreadsheet. Legal feasibility asks, do the documents let the capital stack work under the senior loan? That is the operating agreement, the private placement memorandum, and the loan rules working together. Financial feasibility gets you in the room. Legal feasibility gets you funded. For Regulation D private placement equity, the investor money should act like subordinate ownership. Ownership means the investors share in the upside and the risk. It does not mean the company owes them a fixed payment on a fixed day, no matter what is happening with the project. Equity is ownership. A liability is debt. That sounds simple, but the documents can blur the line. If investors get a hard monthly payment right, a required buyback right, a lien on the property, or a foreclosure remedy, the lender may view those terms as debt-like. The label on the first page does not control the lender's review. The terms do. Preferred equity can be fine, but preferred equity means priority inside ownership. It does not mean priority over the bank. A preferred return can also be fine, but the safer structure is often a return that accrues and is paid from available cash after debt service and reserves. Debt service just means the loan payment. Reserves are cash set aside for the project. The point is simple. The bank wants the loan payment and required reserves covered before equity money leaves the project. In plain English, shall distribute is different from may distribute available cash after debt service. One sounds like a hard payment duty. The other sounds like a distribution that waits its turn. Here is a quick example. A sponsor is building a 90-unit project. The bank provides senior commercial debt. Investors fill the equity layer through a Regulation D private placement. To help investors feel safer, the operating agreement says investors receive a fixed monthly distribution during lease-up. Lease-up is the period when the building is trying to fill with tenants. The private placement memorandum also says the investors will have a second lien on the property if payments are missed. The sponsor sees that as a comfort item. The lender sees two problems. First, cash during lease-up may be tight. The bank wants that cash available for debt service, reserves, taxes, insurance, and project needs. If the operating agreement says investor payments go out every month no matter what, that can compete with the senior loan. Second, the second lien gives investors a claim against the same property that secures the bank. If the investors also have foreclosure rights, that means another party may try to take action against the collateral. Senior lenders usually do not want that in a development loan file, so the lender may ask for revisions. The second lien may need to come out. The fixed monthly payment may need to become a preferred return that accrues. The distribution language may need to say payments are made only from available cash after debt service and required reserves. Notice what happened. The economics may not have changed very much. Investors may still have a preferred return. They may still be paid before common equity. But the legal structure changed, so the equity sits below the senior debt. Investor comfort terms can become lender problem terms. So what should sponsors not assume? Do not assume a profitable pro forma proves the project is bankable. It proves the deal might make money. It does not prove the documents fit the loan. Do not assume investor protections stay invisible. Bank counsel may read the operating agreement and the private placement memorandum line by line. Do not assume calling something preferred equity controls the answer. If the terms require repayment like debt, the lender may read the terms that way. Do not assume mandatory distributions are the same as discretionary distributions. The difference between shall pay and may pay from available cash can matter. Do not assume a secondary lien is a harmless comfort item. To an equity investor, it may feel safer. To a senior lender, it may look like a competing claim against the collateral. And do not assume the Regulation D path answers the senior debt issue. Regulation D is about how the securities offering is made. Senior debt review is about cash flow, collateral, and payment priority. Those are related, but they are not the same question. The better sequence is to build the capital raise and the senior loan requirements together. If the senior lender will require no competing liens, debt service first, and investor distributions only from available cash, that should be reflected before the investors sign the documents. It is much easier to tell investors up front that their distributions and return of capital are subordinate to senior commercial debt than to come back later and ask them to approve a rewrite. The final field note is this: the capital stack is not a spreadsheet. It is the legal order of the money. A development deal can be profitable and still not be bankable if the investor documents fight the senior debt. In real estate development financing, Regulation D private placement equity needs to function as subordinate equity, not as competing debt, a secured claim, or a hard payment obligation ahead of the bank. Build the equity documents and the senior lender requirements together. That is how the capital raise and the loan can coexist. The longer written version is in the show notes.